In this video, I'm going to be examining what happened when Lucy Letby was cross-examined on the case of Child E. I want to preface this by noting that this was the case in which Lucy Letby broke down in tears in court and court proceedings had to be interrupted. This was one of the several lies that we've caught Nick Johnson saying during the court case, where he implied or strongly asserted, in fact, that Lucy Letby had not cried over any of the babies. Now, this instance where she cried over the traumatic death of Child E only preceded these comments by a few days. It was just over a week. Nick Johnson will definitely have remembered this. Nick Johnson will definitely be aware that Lucy Letby had cried over babies and cried over babies in the immediately preceding days to these questions. So that's an interesting way to preface this discussion, and it doesn't get any better once the cross-examination begins. So I apologise firstly that the transcription document here is slightly blurry, but it should still be readable. So this begins with prosecuting barrister Nick Johnson, who is now going to cross-examine Lucy Letby on the case of Child E. Nick Johnson begins, "We're going to move on now to the case of baby E, all right?" "Yes," Lucy Letby says. "Is it your case that staffing levels contributed to the collapses of death of baby E?" "No." So immediately we're seeing Johnson here requiring Lucy Letby to give an explanation. So this is a very clear strategy that the prosecution used all the way through the trial. The idea that it is Lucy's responsibility to explain what occurred to every single infant on the unit. As we saw in the police investigation, the police also required Lucy to explain to what occurred to every single infant on the unit, which is obviously, very obviously preposterous. But once you get to court, the prosecution just uses it as a strategy. It's very evident the more that you examine this case that the prosecution is just willing to say or do anything. And this is a very normal strategy. It's a very normal approach. This will happen in all court cases or many court cases. Sometimes the prosecution is so straightforward or the person pleads guilty. They don't necessarily have to do this. But then, having said that, I've recently examined a case where the defendant pleaded guilty and was definitely guilty, and that didn't make it a more fair or balanced or reasonable process. So right at the start of this cross-examination of Lucy Letby on Child E, we just see some ludicrous arguments and ludicrous lines of questioning immediately. So he moves on to ask several other things. "Is it your case that medical incompetence contributed to his collapse or death?" "Possibly, yes." "Whose medical incompetence?" "The medical team that were on that night." "And who in particular are you suggesting was incompetent?" "I don't think it's being incompetent, I just think collectively the doctors could have acted sooner to respond to his bleeding issue on reflection, seeing how much blood he had lost and what transfusion he was given or not given." Now, there is some further discussion of this in a second, but before we go any further, let's be clear that Lucy Letby is absolutely correct in this assertion. So I'm going to go through the medical information for Child E in some detail. So Child E, or baby 5 as it's expressed here, was born on the 5th day of the 30th week of gestation, so it's 29 weeks old. He, I should say, 29 weeks old. 1.3 kilograms birth weight, monochorionic twin, male infant, born by semi-elective cesarean section for twin transfusion syndrome with oligohydramnios. Antenatal ultrasound showed dilated small bowel loops and absent reversed end diastolic flow. I'm going to explain all these things imminently. Child E required bagging at birth and continuous positive airway, a form of respiratory support, for apnea, a form of breathing difficulty. He showed signs of infection with low white cell and neutrophil counts and high blood sugar, which were treated with antibiotics and insulin. Chest X-ray was clear. 4 days later, he developed respiratory distress, desaturation, chest recession, oxygen need, and bilious aspirates from the nasogastric tube but the abdomen was soft and not distended. He had 2 episodes of massive gastrointestinal bleeding with at least 25% of estimated total blood volume aspirated from the nasogastric tube. He was given normal saline, but 40 minutes later he suddenly deteriorated with desaturation, poor perfusion, low heart rate, and purple patches of discoloration over the abdomen. An hour later he collapsed again and died despite resuscitation efforts. So I'm going to go into these things in more depth, but I think one of the things that I would reflect on immediately, aside from the massive estimated blood loss, which is over 25% in all probability, is that if your takeaway from that is the significant thing is the purple patches of discoloration, then that's pretty laughable, I would say. But we'll look at all the individual aspects of this infant's clinical signs as we go on. So the panel quite rightly knows that child E was at high risk because he was preterm, had twin-twin transfusion with oligohydramnios, and his antenatal ultrasound showed reversed end diastolic flow and dilated small bowel loops. So at the end of this process, I'm going to take you through each of these conditions. But often I will do a summary of why an infant was high risk or whether an infant was high risk. I really don't think it's necessary here. So we can just simply assume that this is a very high risk infant. That should be obvious. So oligohydramnios is a condition during pregnancy where amniotic fluid is lower than it should be. Amniotic fluid, of course, in the womb surrounding the fetus during pregnancy, protecting it from infection and umbilical cord compression. Amniotic fluid also helps develop a fetus's digestive and respiratory system, as well as regulate its temperature. So this condition is only present in 4% of pregnancies. It is quite a rare condition. It's not so rare that there wouldn't be a certain number of cases of this possibly in a hospital over a yearly period on average, but it's not something that most mothers will experience, that's for sure. Too little amniotic fluid can cause health issues in the fetus or be a sign of an underlying problem in the pregnancy. I would say both apply here. These conditions could affect fetal developments or cause complications during labour and delivery, which of course both occurred here. Although, as there was no effort to include any obstetric or maternal information at any stage during either the investigation or the court case, this wasn't properly investigated. Oligohydramnios can cause miscarriage, preterm birth or stillbirth. Of course, it was a factor in the preterm birth of this infant. It can also cause breathing issues, and indeed this infant was struggling with respiratory distress. This reverse end diastolic flow is a strong indication as well of placental insufficiency, which is not surprising in this case because of monochorionic twin pregnancy, meaning they share a placenta, meaning placental insufficiency is very likely. I'm not qualified to comment on this any further. I just know for a fact that's the case from speaking with Martin Pittman. I could look up some statistics, but this is just known to be the case. This condition again is associated with respiratory distress syndrome, necrotizing enterocolitis, and long-term neurodevelopmental impairment. Available data suggests that women with high-risk pregnancies, such as preeclampsia, gestational hypertension, and intrauterine growth restriction, should be evaluated with umbilical artery Doppler velocimetry, do you think it is? Velocimetry, to reduce the possibility of perinatal mortality and morbidity. I'm not going to go into all of these terms. I just want to look at the main ones that are related to the panel. Twin-to-twin transfusion system is a rare pregnancy condition affecting identical twins or other multiples. TTTS occurs in pregnancies where twins share one placenta and a network of blood vessels that supply oxygen and nutrients essential for development in the womb. These pregnancies are known as monochorionic. Sometimes the vessel connections with the placenta are not evenly dispensed, and there is an imbalance in the blood exchange between the twins. One twin, the donor twin, gives away more blood than it receives in return and runs the risk of malnourishment and organ failure. The recipient twin receives too much blood and is susceptible to overwork of the heart and other cardiac complications. During normal pregnancy, the placenta is the source of nutrient exchange between the mother and her fetus. The blood vessels in the umbilical cord of the baby are responsible for linking the circulation of the baby to the circulation of the placenta to allow this nutrient exchange. When there is more than one fetus, such as a twin or triplet pregnancy, two types of placentation are possible. Most common is dichorionic placentation, where each fetus has its own placenta. When both fetuses share one placenta, this is called a monochorionic placenta, rare and particularly challenging. And then there's comments here that complications such as TTTS, TAPS, and SIUGR may present as distinct or mixed clinical pictures. So I'm just going to explain these quickly. Twin anemia, polycythemia sequence, rare severe complication that's not relevant here, and selective intrauterine growth restriction that's also not relevant here, but we see it in other infants. I don't think there's any suggestions that this infant was struggling with intrauterine growth restriction, even though the infant is premature and low birth weight, particularly low birth weight being under the 1.5 kilograms. That means it's a very low birth weight infant. And then dilated small bowel loops indicate the intestine is widened, usually due to a mechanical obstruction or functional disorder. This condition restricts the passage of food, causing abdominal pain, vomiting and bloating, and is often a medical emergency caused by post-operative adhesions, hernias or tumours. So this is yet another infant suffering with abdominal issues. So to return to the discussion here of the panel, this means that blood is being sucked out of the fetus at the end of each cardiac cycle, and the intestines were likely damaged before birth. The two episodes of massive gastrointestinal hemorrhage were most likely due to in utero hypoxia, causing stomach or small intestinal ulceration and erosion into an intestinal blood vessel, or to a vascular abnormality like de Lefoy's lesion, which can cause life-threatening hemorrhage. A 25% blood volume loss was likely an underestimation because more was likely lost in the intestine. So this is an enormous amount of blood loss for anyone. It would render anyone vulnerable. I've been over this previously in previous videos, but for an infant of this size and prematurely, this level of blood loss renders the infant vulnerable to death immediately. Emergency transfusion with Group O negative blood should have been immediately given earlier during resuscitation. Since 20% blood loss causes shock and baby 5 lost much more, this was fatal. Indeed, it's hard to understand why they weren't much more attentive when it came to the emergency transfusion. This would just seem to be an absolutely essential thing to do, and how they managed to get this so wrong. It's probably due to inattentiveness on the unit, the lack of ward rounds, the lack of monitoring, all the things that we've discussed many times previously. So there's some discussion of the skin discolorations being related to hypoxia. Frankly, I don't think they've gone down the road because they're very thorough, but there is no prospect that the clinical signs of this infant were caused by the injection of air. I mean, it's frankly completely laughable. So to return to the statement made by Lucy Letby, there are two major mistakes here. The first one is the failure to give emergency blood transfusion in a prompt fashion, and secondly, it's incredible there was no post-mortem for this infant, and somehow the parents were, cajoled or somehow convinced that this wasn't necessary when it very obviously was necessary. Now, what I'll say before I go any further is that I've spoken to numerous neonatal experts in relation to this infant. I can't reveal the names of all these people yet, but you'll find out soon enough. And they all agree that it's a very obvious, naturally occurring gastrointestinal bleed. There can be no other reasonable explanation for what has occurred here. So what the court ultimately heard in relation to Child E is farcical. And in relation to this, I'm going to show you a few things that Dr. Evans says. Now, in the foreseeable future, I will analyse the entire cross-examination of Dr. Evans for Child E, but I'm just going to show you a few comments that are very easy to pull out from his cross-examination. So firstly, we see Dr. Evans saying, yes, this was a good marker again of well-being, and they'd recorded he was moving well on handling, so that's a good sign again. Premature babies, particularly if they're handled and they're not very stable, they're not very well, dislike handling, and it could lead to irregularities of breathing, stopping breathing. increased or decreased heart rate, a drop in oxygen saturation. In other words, all these are markers of babies not being as well as you'd like, and therefore, which is why you need to handle them as little as possible. So therefore, if they're moving well on handling, and they're handling well, which is the term used, if they're handling well, it means that they don't have any of these markers that suggest that there is something wrong with them, or something unwell with them, I should say. This is the kangaroo care record. Kangaroo care is where the baby's brought out and nursed, held by its mum. And again, you'd only consider kangaroo care once the baby is stable, because, as we've heard, if babies are handled and they're unwell, they can deteriorate. Therefore, the presence of kangaroo care and that he was coping with kangaroo care meant that he was a very stable, well little baby. Again, he's coped with his kangaroo care, he's coped with the handling involved with kangaroo care, his condition is extremely stable, his heart rate findings are normal, his oxygen saturation is satisfactory, and there aren't any abdominal concerns. You know, there's no abdominal distension, bowel's not open yet, pretty much quite common in little babies, but he's got BS present, bowel sounds present, so a good sign, normal sign, and no suspicious aspirates, which relate to, if a baby's intestines aren't working very well, you'll get aspirates up the nasogastric tube. So a very, very stable little baby, and anterior fontanelle soft, i.e. normal. So this is what Dr. Evans does in the court case for all infants. He will pick a few signs, readings, or anything at all really that he can fasten onto and claim that this is normal. Sometimes it's only one sign. He will then cite this as an indication that the baby is stable. He will also then discount all of the signs that the baby isn't stable or well, while emphasising the things that he has cherry-picked. He will also isolate and particularly emphasise one thing in particular, and then make claims such as he has never encountered this before, or there is only one possible explanation for this, deliberate harm. So in the case of child E, when we're talking about the first one, he'll pick a few signs, readings, or anything he can fasten onto and claim it's normal. This was a good marker, again, of well-being, it's a good sign, blah, blah, blah. He will cite this as an indication the baby is stable, so he's this thing I've just read out about kangaroo care and so forth. And he's a stable, well little baby. Very stable, indeed. Then he'll discount everything else, indicating the baby isn't stable and well, and emphasise the things that he's cherry-picked, so you see him doing that here. And then finally, this is something I haven't read out from child E. He'll isolate and particularly emphasise one thing in particular, and then make claims such as he's never encountered this before, or there is only one possible explanation for this deliberate harm. So here he said, well, this would have been completely unexpected given baby E's condition, stable condition previously. It really would be difficult to explain how a baby is stabilised out for several days and has now got blood from its mouth and was making what we heard the other day was this horrendous noise. So it's not something I think I've seen actually, other than this case. So I could go on reading more, but I just wanted to explain. I've seen enough of Dr. Evans now to know exactly what he does in court. He does the same thing every time, exactly the same thing. I can pick out these things. I can easily pick out where he's done it in this case. It's really not difficult. Now, I want to be clear that I'm always very careful what I say, and I don't wish to make any assertions in relation to this. I'd allow people to draw their own conclusions. You may also make comments in the comments section that I don't endorse. That doesn't necessarily mean that I don't agree with them, but I'm just very careful about the legal aspects of this case. But I'm sure that you can draw your own conclusions from what I've just presented. Let me emphasise once again that anyone else that looks at this case with neonatal, paediatric, I would say even general medical qualifications, in fact I don't even really think you need medical qualifications, will conclude that this infant passed away due to a gastrointestinal hemorrhage, as the panel has concluded. And we're going to return to the court transcript, but I really wanted to take a little bit of time here just to show how egregious this is, because there's no chance this should be in a court, ever. It's an absolute joke that this is in the court case. And Lucy Letby's facing a life sentence over this infant because the court has been presented with this information that is deeply inaccurate and deeply unreliable, I would describe it as. So we'll return to the court transcript now, and I'm not going to go through all of this in this video because there's 94 pages. It needs to be 94 pages because Nick Johnson has to try to explain how an infant that is very obviously suffering a gastrointestinal bleed where it's absolutely blatantly obvious that the unit should have responded more quickly and that there were massive medical errors. And really, these parents have another, in addition to child D, this is another obvious negligence claim. So Nick Johnson has to concoct some ridiculous narrative in which this isn't the case. Of course, we already know this is an infant as well, I must emphasise, where he definitively lied during the closing speech because he said the parents caught Lucy Letby red-handed, when it's agreed evidence this never happened. Then he goes on to make the surreal claim that they didn't realise what they'd seen. Just absolute nonsense, but you're going to see a fair bit of nonsense in this case, and it really is. This is almost, it must be painful for people that have medical qualifications to go through this. It's painful for me. And I'll go as far as I can, and when I think I've spent a reasonable amount of time, then I'll stop and I may revisit it at a later date, probably will, in common with other things that we're going through. But when Lucy makes this comment about collectively the doctors could have acted sooner to respond to this bleeding issue, she's absolutely right, of course. So Nick Johnson has to try and somehow explain this. So he says, so reacted sooner, yes, or treated the bleed. Well, of course, their reaction will be dependent on when you told them there was an issue, wouldn't it? And she says, yes. And you understand, don't you, that we, the prosecution, are suggesting that you didn't tell them as soon as baby E did start to bleed? Yes. So this may be... I don't want to be critical of her in the witness box, but this may have been where she could have said, for example, yes, but of course I did inform them immediately as soon as I knew, or words to that effect, whatever the situation was. Just saying yes leaves it rather hanging in the air. You know, the prosecution here is essentially making an assertion, and she's not contradicting that, which she should. But it's very, very hard up there. Because you will understand that it's the prosecution case that mothers, baby E and F is telling the truth, and baby E was bleeding at 2100 hours. Yes. But you didn't tell anybody about that until at least an hour later, did you? No, I don't agree with that. So she should probably say, no, that's untrue. But it's difficult because, or it's a mistake or whatever, and I informed the other people on the unit immediately as soon as I recognised bleeding. She probably should be more assertive there. She's probably a little bit nervous, or, she wants to be delicate because she doesn't want to say the parents are lying, because then that would be held against her. Very, very difficult situation. But she probably should be a little bit more firm than say, no, I don't agree with that, because it doesn't sound affirmative enough, in my view. But it is so difficult. When are you suggesting that something that wasn't done should have been done? I think once baby E was profusely bleeding after 10 o'clock, maybe a blood transfusion or something could have been given sooner. I don't know if that would have made a difference to him. Of course, Lucy is completely correct about that. Right, to whom do you attribute that mistake? The medical team collectively, that's a medical decision. So Dr. Hartness and the other doctors. It was Dr. C, I believe, who was the consultant. Another doctor in this case who's bizarrely allowed to remain anonymous for absolutely no good reason whatsoever. Yes, was there another doctor on that night? Only from his evidence, Dr. Wood. Yes, Dr. Wood, the SHO, yes. And we'll come back to him soon. So one or a combination of these three medical practitioners. It's a medical decision, yes, to prescribe and give a blood transfusion, yes. During the evidence relating to baby E, do you remember that your friend Belinda Williamson gave evidence? So I'm not going to go any further at this point. I'm just going to pause for a second. So the prosecution is going to make this claim that we've seen during the closing statement as well, that there was an hour pause. So somehow Lucy Letby has inflicted an injury on this infant. Dewi Evans initially suggested it was with a nasogastric tube. Then he realised that he was wrong. So then he just made up that it could be another object. Never specified what object it was. This is a complete fabrication, of course. And then, supposedly, Lucy Letby just stood around for an hour watching this baby bleed without raising the alarm, and no one noticed anything and no one did anything. And then all of a sudden, she raised the arm after an hour when she was confident the baby had bled enough, presumably. I mean, it's absolute rubbish. It's completely untrue. It's very obvious the prosecution case is completely incorrect. But we're going to see a very long cross-examination of Lucy Letby attempting to justify the prosecution case. So they're going to talk a little bit about Belinda Williamson here. Belinda Williamson was asked about the plumbing and the drains in the neonatal unit when she gave evidence on the 16th of November. Do you remember those questions? I can't remember specifically, no. what have the plumbing and the drains got to do with the death of baby E? And Lucy says, not unreasonably, I don't think I have ever said that they have got something to do with the death of baby E. I think it's an important factor to note that there were often plumbing issues within the unit, which is a fair comment. Of course, the plumbing and drainage issues and the fact they've got sewage on the unit and basically endemic sepsis and, of course, these other infections, the plumbing and drainage is relevant to that, and the plumbing and drainage is relevant to the clinical picture of those infants, and it can be a significant factor in deterioration. Of course, because Dr. Dewi Evans was the primary prosecution witness, the court heard that all the infants were well and that infection wasn't a factor, and therefore the prosecution case is that we'll just discount the plumbing and the drains. But this is just what prosecution does. This is the way that court cases work. So I don't know whether the judge should intervene here. I don't know what is or isn't reasonable. It seems that anything goes in a court and you can just basically say whatever you want. You can be criticised by previous judges for your so-called expert evidence being worthless. They don't really care about that. I'm not sure what you'd have to do to be thrown out of a court case or to engage in a line of questioning that the judge would intervene on. I'm not sure when that would ever happen based on this court case, but it seems that this is perfectly acceptable. Of course, on any kind of reasonable intellectual basis, the notion of cross-examining Lucy Letby and expecting her to explain everything on the unit is preposterous, but this ludicrous approach, at least it kind of makes sense here because the prosecution's just trying to win. The police have already done this previously. The police were expecting Lucy to explain, oh, this is why this infant died, this is why this infant died, this is why this infant collapsed. Across every single collapse, you've seen how complex the medical conditions are and how nuanced they are and how different they are from one infant to another. Not like when Dr. Dewi Evans gets into gear and says, oh, it's all just air. Everything is just air, and if there's a condition, if there's some sort of clinical sign that I have to explain away, then, I'll make something up like Lucy Letby punched the baby or Lucy Letby stuck something down, just total crap, essentially. These are very nuanced, very complex cases, as neonates typically will be, and that's why the paediatricians and the registrars who worked on this unit couldn't identify the problems and didn't identify the problems. And that's not just according to the panel, that's according to the pathologists who examined the babies as well. And Lucy says, I don't think I've ever said that they've got something to do with the death of baby E. I think it's an important factor to note that there were often plumbing issues within the unit. Of course, she's absolutely correct, because this can be a significant factor and is a significant factor in infection on the unit. And then Sir John's saying, what has that got to do with the death or the collapses of any of these children? I'm not saying that it is, but I think it's a contributing factor if the unit is dirty and staff are unable to wash their hands properly, or we used to have raw sewage coming out of the sinks, running onto the floor in the intensive care nursery, and I think potentially that's not a safe working environment. I don't know what effect that might have on a baby. So that is reasonable, of course. There's a reason that she's being asked these questions. It's difficult for me to give this any credence at all. As someone who would consider themselves to be an intelligent person, obviously I'm an adult, so I just view what happens in court as just being this very juvenile process that just has no intellectual or evidential merit at all. But this kind of line of questioning continues where they're talking about the sewage, even though it's completely irrelevant. This infant has died due to a gastrointestinal hemorrhage. This infant could have been weakened by sepsis, potentially. The panel has not come to that conclusion, but it's perfectly feasible that infection could have played a part. But this infant has so many chronic problems and was so poorly treated, the demise of this infant was essentially inevitable. If you lose this amount of blood and then there isn't a transfusion, the infant is going to die. That would apply to a full term infant that was nowhere near as unwell as this infant. But for an infant of this size, gestation, etc., the transfusion is critical. So this is all pointless to discuss because it's completely irrelevant. But let's continue. So he asked, when did you first mention the sewage? I talked about there being sewage coming from the sinks to the police. Will we find a Datix form with raw sewage coming out the sink in Nursery 1 on it? Not from myself, no. Or are you aware of anybody putting in a Datix form? I don't know, but we often had the plumbers in attending to the sink in nursery 1. So you're saying that the wastewater was attached to what? The soil pipe? Yes, we used to get backflow from the theatre sinks, and in the CLS labour ward theatre sinks, we used to get sewage coming back through the sink, yes. So let's just emphasise once again, this is all completely true. This is all absolutely true. It's not contested. It's commonly known about on the unit. There wouldn't be any need to fill in a Datix form because the consultants on the unit who are ultimately responsible, they are in seniority to Lucy. It is their responsibility to ensure that the unit is a safe environment. They are aware of the sewage. We know that they're aware of the sewage. That's why they're called the plumbers out. So it's not something you put on a Datix form. On a Datix form, you would put in medical errors and things that you can learn from as a team. You may conceivably put sewage on a Datix form, I suppose, but it's not something that you need to learn from because everyone knows that there shouldn't be sewage on a neonatal unit. Everyone knows they need good sanitary conditions. There shouldn't be sewage flowing up the sinks and onto the floors. Obviously, I mean that's just disgusting. It's not just unsanitary; it's disgusting. Would you want to wash your hands in sewage? You imagine if you're in your home and you're just washing your hands, and then sewage comes out. You'd have it dealt with immediately, and I guess you'd have very serious considerations about whether you went to stay somewhere else until it was sorted out. Particularly, imagine if you had a baby in your house and you knew there was sewage coming out of the sink. This is a neonatal unit. So you're hardly going to put in the date. Maybe you should. I don't know whether you should put it in the Datix form or not. But it's not something that needs a lot of reflection. You don't need to get around and have a team meeting and think, do we need to worry about this sewage or not? Well, I think maybe we don't because I'm not sure sewage is an issue. Obviously, they need to worry about it. Obviously, the paediatricians are aware of it. It should have been dealt with. In fact, as you've heard doctors say on this channel and in the panel event, in the panel press conference, the unit should have been closed down. Never mind the Datix form. So then he goes on to say, no, you did fill in a Datix form relating to the death of baby E though, didn't you? Yes. So all that is just time wasting and trying to make out that Lucy's lying or unreliable. It's just a typical thing of trying to destroy the witness with, we see this throughout the case, just throwing in irrelevant things, trying to confuse the jury, just anything other than actually putting legitimate evidence forward. But you can't put legitimate evidence forward for this because the prosecution case makes no sense and is untenable. So there has to be all these tricks and all this. Frankly, it's just bullshit. So anyway, they're going to talk about the Datix now. I'd just like to have a look at that, please. It's tile 218. We'll click on it, please, Mr. Murphy, just so that we understand under what circumstances do you, and I'm talking about from your personal perspective now, under what circumstances do you fill in one of these forms? Datix is completed as standard procedure if there's any death on the unit, and then is there for any other issues that I myself might want to raise that need looking into, so any concerns I might have or anything that's gone against policy, anything that I need escalating to be reviewed by senior staff. So again, before we go any further, I want to emphasise once again, I've had a neonatal nurse examine all of the Datix information that is available, and she concluded that Lucy was the most conscientious compiler of Datix information on the unit. That was also noted by nursing managers on the unit, and I've spoken to people who know Lucy personally, and they have stated, in a nursing capacity, I should say, and they have stated that she was always incredibly conscientious about stuff like this. So I'm not sure how it could be suggested that Lucy's Datix practice is somehow wrong on a unit in which there were obvious problems with Datix practice. But let's continue. You filled in this form, did you? I don't remember from memory, but I'm assuming this is. All right, I can't. As we've said many times, it isn't a memory test. Does the person who fills the form in effect, digitally sign it? Yes. And I think we'll see that on Let's Go to page 2, if we could, please, about a third of the way down. That's it. So we see incident reporter there, don't we? Yes, so I filled in the form. Another thing to mention at this point, yet another thing, is that at this point, they're going to use this Datix form to make some sort of tenuous point. So therefore, they're now saying the Datix record is reliable. At other times, the Datix record quite consistently on numerous occasions contradicts the prosecution case. So at that point, the prosecution has to bring in its fabricated argument that Lucy, she either altered Datixes, or she made stuff up, or she changed them, or she fabricated evidence, or they're unreliable somehow, none of which there is any evidence for at all. They just concocted that. They made it up. Whether you could describe it as outright lying or not, I'm not sure something is lying if it's just fabricated. It's just completely fabricated. On this occasion, the Datix supports the point that they want to make. They did this with the swipe card record as well, where the swipe card record sometimes wouldn't support what they wanted, so when it didn't, they just said, oh, well, someone could have just followed you in, or it's not reliable at this point. But it is reliable at this point where we decided we want to say this. This is just yet another example of the prosecution, who basically, it is their job, not just... It would be officially stated that their job is to prosecute, but really their job is just to put forward any argument they possibly can to convince the jury, to manipulate the jury. It doesn't matter if there's any foundation, any basis for it, let alone whether it has evidential validity. It's just their job to say, right, we're going to say this now. We know it's untrue, but we'll just say it anyway. Now we're going to say this. We know this is untrue, but we'll just say that anyway. And this happens consistently throughout the court case. Every single time I examine fragments of the court case and the court transcript, we see the same things, the same patterns, the same conduct. So I'm going to go through this next section of the cross-examination of Lucy Letby, and I think it will be interesting to contrast this with what the defence said in the concluding statement of Ben Myers. Okay, Nick Johnson says, and is there some way of knowing when this form was filled in? I think at the very top of the form, I think there's a date and time if I'm correct. I'm not... Okay, if Mr. Murphy would oblige, please. So there, it was submitted on the 4th at 5:53. So that's you opening it, is that right? That's the time the form is submitted, so that's when it was filed and saved. So this is an electronic process, is that right? Yes. And do you have to put in your personal PIN number or something to access the blank form? Yes. Just as we scroll down it, would you tell us which bits you filled in? So the ID and the name and the reference, are they... No, that's automatically generated by the computer. Even the name? Sorry, yes, because it's part of the Meditech system. So what, you log into Baby E's individual case, is that right? Yes. And this list of data that we see there self-populates. From memory, I think so, yes. Alright, so we go to location, which is the second section. Is that self-populated as well? It's something I would fill in. It's a drop-down box that you have to select from. The coding section next. Yes, that's me. Well, not the bottom two, but the first 4 lines. So clinical incident neonatal unit, it says pick list. Is that where you're hitting a drop-down menu? Yes. You can see what kind of crap this is. The subcategory we see this has got nothing to do with the result of staffing levels. No. Which is your selection? Yes. Risk grading, is that what you put in? No, I'm not sure about that. It says no harm caused, doesn't it? Yes. Which certainly doesn't make sense in the context of what we see in the next section. So details, incident date selected by you, yes. The time of the incident selected by you, yes. The fact that it's an unexpected death following a GI bleed, full resus unsuccessful. And then you have inserted the time of death, is that right? Yes. Actions taken and report to NRLS, is that done by you? No, the last input I have there is the action taken. Those bottom 2 rows, they're not entered by me. I'm not sure what they stand for. I think RIDDOR is something to do with the Health and Safety at Work Act, but we don't need to worry about that in the context of this case. If we scroll down, please, the next section, is that completed by you? Yes. The duty of candour? Yes. Then the incident investigation. Please use this field to document all updates in relation to this investigation. That has somebody else's name against it? Yes. Is that anything to do with you? No. So patient details, plainly you? Yes. I'm not sure if they are automatically generated or if I put those in, but yes. The next section, please. Incident reporter, you? Yes. Then we have linked claims, linked records, nothing to do with you because that's open, we see, on the 2nd of August 2017. And that's got somebody else's name as the handler. That's not myself. Alright, can we go down to the next bit, please? And we then have something to do with other documents, but I would just like to scroll down, please, and keep going. SBAR, is that anything to do with you? No. This is what's been completed at the review meetings by the staff that were listed above. Then, continuing down, please, there's quite a long history of what happened to Baby E and when. Yes. Nothing to do with you, is that right? No. And then we can keep going, please, and again, please, all this nothing to do with you, is that right? No. And then the SI panel meeting, again, nothing to do with you. That's a meeting that happened in August 2015. That's right. SI tracker, again, nothing to do with you. No. Can we continue? Any of this on the final page, anything to do with you? No. If we can continue, can you just identify anything else that is anything to do with you? No. They're all just blanks, aren't they? They are, yes. If we keep going, that's not me. No. That's not me. No. No. Okay. So does it come to this, therefore, that so far as your input is concerned, it's simply in effect reporting the death, so what is at the bottom of the very first page? Yes, so it's standard practice for baby dies that we select that on a pick list and submit a Datix yes. I want to just deal with baby E's course of treatment and presentation before he came under your care on that night shift of the 3rd of August. So you notice he does all that stuff then has no follow-on points. That's all part of this convoluted argument that Johnson is going to make. So I'm going to contrast that now with what the defence actually stated. You've seen the substance of argument, and I've been over child E already in the closing statement of Johnson, and then I'm going to return to reflect on the contrast between the prosecution and the defence here. So I'm going to go through not all of the comments that Ben Myers made in his closing statement with regard to child E, but some of them. I'll probably go through the whole thing at some point in the future. Count 5, ladies and gentlemen, baby E. Baby E was born on the 29th of July 2015 at 17:53, so 7 minutes to 6 in the afternoon. He was 29 weeks and 5 days gestation. The first of the two twins, baby F, was his brother, and he was 1.327 kilograms in weight. On the 3rd of August 2015, during the shift going from that evening into the night, he bled at various points. At 23:40, there was a desaturation and bleeding continued, and with a further collapse round about 00:30 or thereabouts, and he died in the early hours of the following morning, 01:40. Dewi Evans, Dr. Evans, says that death is due to air embolus and trauma causing hemorrhage, and Dr. Bowen says death is due to air embolus, and I put question mark trauma. She wasn't so clear about that, but it was there. There are particular issues to consider in baby E's case. I'm going to look at it with this structure in mind, although there may be some deviations along the way. First of all, whether baby E received the care he required as his condition deteriorated late that night and into the early hours of the morning. Straight question, did he get the care he needed? Whatever was going on, remember what we say about blame in this case and which direction it's going in, and the reticence in some quarters to accept it. So did baby E get the care he required? Secondly, we'll look at whether the evidence shows Lucy Letby attacking baby E around 2100, which is the starting point presented to us by the prosecution. Attacking him. Third, we'll look at whether baby E's condition is as described by mother of baby E and F to the police at around about 2100. Fourth, we'll look to see whether the theory, the allegation, that baby E died because of an air embolus is supported by the evidence, because, crucially, that's the prosecution case. And then also we'll look to see what evidence there is of an attack causing trauma upon which you can be sure, as opposed to a bleed that developed in some other way. We don't have to say how the bleed happened. I don't say that to be belligerent or difficult, it's the law. Quite rightly, if I may respectfully observe, that we don't have to, we not may be able to. What has to happen is the prosecution make you sure of harm, and they propose two mechanisms, so you need to look at the evidence of that, and you, ladies and gentlemen, will keep in mind throughout, of course, that there was no post-mortem in this case, of all cases, a case where the issues so badly require that for resolution given what's said. There was no post-mortem. So you'll see already that the defence has presented several things that have now been cited by the international panel already. Let's continue. So first question, did baby E receive the care he needed? We say, no, he didn't. Actually, he didn't. I'm talking about the bleeds in particular. The failure to react to the bleeds, the failure by Dr. Hartness and Dr. C, the consultant, is obvious, we say. The GI bleed, the gastrointestinal bleed, had either been identified or strongly suspected by David Harkness at about 20 to 10 on the 3rd of August. It had been. Can we put up TAR 128, please, Mr. Murphy, from the baby E sequence? Here we are. This is the first note, and you'll remember we went over with Dr. Hartness when he would have attended on the unit, and I will come back to this, but it's probably about 9:30. He could have been there to have done all this and then made this note. But anyway, asked to see patient re-gastric bleed. So he goes through all of this. He does the examination, no wounds to the throat. You remember that was something that was floated, one of the many theories in this case, no evidence of that. Can we go over the page, please, just to see his conclusions? And we can see there, suspected GI bleed, query cause, which is consistent with what he saw. He prescribed ranitidine, which is something prescribed to reduce acidity to assist with a situation like this. That's why he prescribed it at this time. I should mention that this is now a banned drug in numerous countries, and the prescription of ranitidine can certainly have caused problems in some of these infants. The defence chooses not to focus on this, but it is certainly a relevant point. We say that, in fact, from this point, given the bleeding which had commenced, it was obvious that a transfusion would be required, and certainly by the time we get to 2300, if we scroll down a little bit further, we can see there 2300 further gastrointestinal blood loss. Nothing about from the throat, by the way, nothing at all from the clinician, a suggestion thrown out there by the prosecution put into that pattern. It's not. Further GI blood loss, 13 millilitres blood-stained fluid from NGT, obviously meaning nasogastric tube. Substantial and ongoing blood loss, no transfusion, no note preparing transfusion up to this, no cross-matching. The things which you'd expect to happen as preliminaries to prepare for transfusion. And Dr. C didn't get to the neonatal unit for about 1.5 hours after she was first told about the bleed. She got there at about 12:25 or thereabouts. Now, when I cross-examined her on the 16th of November, to her credit we say it's a matter for you, she agreed this was a serious situation by 10 p.m. and a very serious situation by 11 p.m. that was now a medical emergency. She agreed. She should have been there before she actually arrived at 0:25, and she agreed that. She agreed she should have got there sooner, and she wished she had. That's what she said. I wish I had. The only certainly senior doctor to accept responsibility in that way for anything in this case. Just let that sink in for a second. Of course, if there's nothing to accept responsibility for, why should any of the others? But we say there is plenty, unfortunately. The reason she should have got there sooner, ladies and gentlemen, is, of course, she was overall responsible for what was happening with baby E. We say it's not accepted, it's a matter for you, but this is obviously suboptimal care. You have the evidence. You don't get admissions the full way from doctors in this case on that issue. We say you're not going to get it, and you'll keep in mind what Dr. Evans said about the reluctance of doctors to admit the mistakes they make. This isn't a criticism of all doctors, but we say it does apply here, the situation in general. Now, what I would say in addition to this section, which is very revealing, is that I think there are two important things to note here. The first one is that we really do put doctors on an almighty pedestal, and as soon as the jury sees doctors saying something, even though they've been told here what you've just heard, that is undeniable in the case of Child E, and frankly it's undeniable across the case as a whole, but they will still think there's this thing that's sometimes referred to as the white coat effect, where they just believe doctors. The second thing I will say is it would certainly have helped Lucy if she'd have had some defence witnesses in court. Now, I can't say why Dr. Michael Hall wasn't called for this case. I'm certain that he would have disagreed with the prosecution, but the fact is Lucy didn't have any defence witnesses. Now, everything that Myers is saying here is correct, undeniably correct, but with the judge essentially ruling this out as being evidence, and it makes it firstly difficult for the jury, and then the jury just tend to think, oh, well, these doctors have said stuff, so the doctors must be right. So that's a major problem for Lucy in this case, and that's one of the many reasons it's not a fair trial. You may struggle to understand how Dr. Bowen could not concede that at the very least bleeding was the cause of death. I mean, to say the least, that is difficult to understand. She wouldn't. We say that is a good example of a stubborn refusal to accept what must be a reasonable possibility. There was profuse bleeding on top of 25% blood loss. It's distressing talking about this, I know that. We have to when we're considering an expert who won't accept that blood loss, bleeding, was a cause of death. Now, I assume the reason that Bohin has done this is that she wouldn't accept trauma. So Dr. Evans tried to suggest there was trauma. Who knows what's going through her mind exactly, but she obviously knows there's no evidence for trauma. So she thinks, well, I can't agree with that. I mean, I've agreed with basically everything else that he said, but I can't agree with that because there's literally no evidence for it. But I know my job is to agree with him on something, so I'll just say I agree with him on air embolism. I mean, the language doesn't exist to describe how ridiculous it is to suggest that this infant that is chronically bleeding lost approximately, is somewhere between a quarter and a third of blood, we can reasonably estimate. And Dr. Bohin said that's nothing to do with why this infant collapsed and died, but I think the air embolism theory is credible. And the rashes are not even close. They're not even close to being what you would need to cite air embolism. And imagine if you were on a neonatal unit. Just imagine if you were a doctor looking at this infant and the infant is bleeding so much that a small amount comes out the infant's mouth, and they give the infant a blood transfusion too late, and all of the internal documents note gastrointestinal bleeding, but you ignore that, you completely ignore that and say it's nothing to do with the death of the infant, but I think the injection of air is the reason the infant died. On no level and there is no one on this planet that would ever do that, and I don't think it even requires medical qualifications. If you, just as a layperson, that the parents must have thought, why is the infant bleeding out the mouth? Why? And if a doctor on the unit, imagine a doctor at the hospital saying to them, oh, well, probably there's been an air embolism. They would be treated with derision, and rightly so, by anyone. It boggles the mind. It truly boggles the mind. And I'm going to talk about this more in the summary, but people sat there in court and accepted this. That's the thing that is most worrying for me. We say the evidence is clear and that tragically baby E did bleed to death when he was not in the right place, where the doctors failed to react appropriately and in time, and most unhappily and surprisingly delayed a blood transfusion for which we never really got a good reason. Simple explanation for that. There is no good reason. That caused the death of this infant. Undeniably. But everybody here could see that this required a blood transfusion. I don't know, you may be doctors and nurses for all I know, I don't know. But even if you're not, it speaks for itself. Absolutely. So, I'm just going to read this out about Dr. Sandy Bohin. Members of two local families have publicly raised their concerns about consultant paediatrician and expert witness Dr. Sandy Bohin, whose testimony was used to prosecute Lucy Letby. They spoke at a conference focused on the convicted murderer's case and calls for review of the evidence on Saturday. The individuals who wished to remain anonymous delivered presentations outlining their ordeals in trying to secure correct diagnoses and treatments for their ill children across multiple encounters with Dr. Bohin. Now, I'm not going to comment on that any further. That's just an extract from a news item. I will just remind you that Dr. Bohin encountered this infant that had definitely, it's agreed, had lost at least 25% of the blood, but probably more. Probably 1/3 of the overall blood capacity of this infant, volume rather, was lost due to gastrointestinal hemorrhaging, and Dr. Bohin concluded that this was completely unrelated to the collapse and death of the infant. I'll just leave you to reflect on that. The second point I said we'd look at, ladies and gentlemen, whether the evidence shows Lucy Letby attacking baby E around 2100. Let's start with this first attacking him. In opening on 11th of October last year, the prosecution said this before you had heard the evidence. Mother of baby E and F interrupted Lucy Letby, who was attacking baby E. That sounds pretty definite, doesn't it? What did you think that consisted of? Well, whatever we get to with the evidence and with mother of baby E and F's evidence, that isn't the description she gives, and that isn't the evidence. The evidence does not show Miss Letby attacking baby E, however many times that is said, We say doubtless for the effect it has upon you and whoever is listening. It doesn't do that. It's a highly charged description, highly emotive, and has been pushed from the start. Mother of babies E and F in her evidence said Lucy Letby wasn't even beside him. She was working at a workstation, and the mother of baby E and F just walked in. Her evidence was she walked into the nursery, which would be unexpected. Whatever the milk times are, generally unexpected, and indeed anybody can walk into that nursery. Busy as a bus station, Belinda Williamson said, a prosecution witness, unchallenged on that. So again here, Myers is emphasising what I have emphasised myself, which is the idea that all these arcane methods of attack can be carried out on a busy neonatal unit. This is not even, it's not even in the morning. This is in the evening. This is prime time for visiting at a hospital. It's preposterous again. And when mother of baby E and F gave evidence on the 14th of November, she said she was busy doing something, but she wasn't near baby E, page 19. So yet again, someone appearing unexpectedly to find Lucy Letby not causing harm. That is the evidence. So that is where we get to on Lucy Letby attacking, or an attack ongoing, being interrupted. Mother of babies E and F interrupting Miss Letby, who was attacking baby E. The evidence is she was busy doing something, and she wasn't near baby E. So in his closing statement, Nick Johnson transformed that into the mother of baby E and F catching Lucy Letby red-handed. Next point, the condition that baby E was in when the mother of babies E and F came downstairs, and as described to the police later. You'll look closely at what mother of babies E and F said, ladies and gentlemen, and we'll be careful with the way we deal with this and sympathetic. Okay, it doesn't mean disregarding any shortcomings in the account when we look at that carefully. The prosecution, we say, have done their best to turn this part of the case, on this part of the count, into what they have called a binary choice. You heard them use that expression last week, meaning either Lucy Letby is lying or mother of babies E and F is lying. And this is why we see Nick Johnson doing this huge preparatory section about the Datix, because they're just trying to set it up as, oh, either you believe Lucy Letby or you believe the poor mother who's lost their infants. And they did exactly the same thing with Child K, where they said either you believe Dr. J.R.M. or you believe Lucy Letby. And they did this all the way through the case. It's not based on evidence, it's just based on an appeal to emotion. We say they haven't done that by accident. That is done deliberately. I think that's... I can't see how anyone could possibly contest that. Who's the liar? It is done deliberately to put the defence and to put you in a difficult position, because no one is going to want to say that the mother of babies E and F is lying, and no one is saying that she is lying. So can we get that clear straight away? That's language used by the prosecution to characterise this situation when they say this is a binary choice. The question is, what degree of accuracy can we place on everything that is said? And I don't say that in some mealy-mouthed fashion, because we need to look at this and see whether or not the way it was described, as the mother of babies E and F told the police as she discussed it, as she's given evidence to you, fits with everything we know at that time, because you have to assess this. That's different from a question of lying, so perhaps can we take the heat out of that by saying this is a question of accuracy and reliability? All very fair comments. Now, as to the accuracy of the count, screaming, alright, screaming. Horrendous is the way that the mother of babies E and F described this. And we say, however that recollection works, it cannot have been like that. It cannot have been for this reason. There weren't just two people in that neonatal unit and a baby. Alright? It's not just the mother of babies E and F and Ms. Letby and corridors of empty space and baby E. It's full of people actually, and people coming and going. We have to keep coming back to the fact that this is happening in the real world on a relatively busy unit, whatever time of day and night. And this isn't, if it makes any difference, right in the middle of the night. It's a fairly busy time, you may think, round about 9 o'clock, if that's the time we're talking about. You will remember the evidence of Belinda Williamson, which I took you to earlier. That piece of evidence is important, and the descriptions of other nurses as to how busy Nursery 1 was. They are important generally in this case, and of course important in the case of baby E, because it makes it less likely that someone has the risk or the opportunity to harm, as it's alleged that baby E was harmed, if they can be caught in the act like that. And it's also important when a witness describes, as the mother of babies E and F does, hearing something she says she heard and screaming like she says it was. It's a straightforward point. How on earth is that not going to raise the concerns of other people who will say, yeah, I heard the most horrendous screaming, I went along, it's the night the baby was bleeding, and so on. We hear things of other nurses who are aware of what happens in other counts. It is striking. There is nobody else describing what the mother of babies E and F describes in terms of screaming at that point, and we say it is unrealistic in terms of accuracy what happened than it can have been in the way she is describing it. Whether baby E was upset or not, he may have been, but screaming horrendously like that is not anything that anybody else suggests took place, and it's difficult to see how that could have gone unremarked in this case. So you see how delicately that has to be put by Ben Myers because of the tactic of putting the mothers of the parents and the fathers of the parents and even the grandparents and other relatives in court. These eyewitness testimonies, these highly emotive, and as we see, highly unreliable with the greatest of respect to the parent. Why would you expect her account to be reliable? It's an incredibly subjective thing and an incredibly emotional thing for us. So not only is it producing an unreliable response from the jury due to the emotive nature, but the emotive nature of the account also makes it less reliable by its very nature. So overall, for me, it's a very disturbing aspect of the court case. But it's not just with the screaming, let's look at the bleed. We know there are issues with the timing and there are matters to look at with that, and the question of bile, the bile-stained aspirate that was there at 9 o'clock, that was there later, we recognise those points, but as to the nature of the bleeding, mother of babies E and F began this part of evidence by saying that baby E had blood coming out of his mouth. That's how it began. In fact, it became apparent on further questioning that it isn't blood coming out of his mouth. We had this. Question, did the blood go anywhere else apart from on his chin? It was on his chin a little bit on the lip, and underneath. Just so we can be quite clear, you're not describing something where there is blood coming out, and it's going on his clothes, or over the bedding, or anything like that. No. It's that you could see certainly what looked like blood. You'd say it was blood, but you could see it round about his chin, in that area like we saw on the picture. And you've seen that picture, and the mother of babies E and F said yes. Pausing there, the description he had blood coming out of his mouth is graphic, and in fact on further questioning, that isn't what was going on in the sense of blood just coming out of his mouth or coming all over the place. I read from the statement, question, it wasn't around his bottom chin and the bottom lip. It wasn't thick. It's difficult to explain what it was. It's like a dribble pattern on his skin. It wasn't completely fresh. Is that what you described, what you saw? Answer, and she nodded and said, yes, a dribble pattern, not completely fresh. However, we approach this and we approach it sensitively and respectfully. That's different, isn't it, from the initial description, screaming horrendously and blood coming out of his mouth. It is different, it's not the same, and it certainly doesn't create the same impression. Page 2, line 33. You may already see where I'm going with this from the timings and who's doing what. Just go back a page, Mr. Murphy. Thank you. In fact, we've got Lucy Letby and Caroline Oakley involved, or first of all, Miss Letby at 2100 dealing with baby F, and also, look at that, Caroline Oakley, 2113, involved in a prescription for baby F, who we know is in the proximity of baby E. This is contemporaneous, or closely contemporaneous with what mother of babies E and F is describing. If we go now over the page, please, still there, 2113, okay, Lucy Letby and Caroline Oakley observations on baby E at 2115. This is just an example, thank you Mr. Murphy, but that's another nurse involved in the care in and around that nursery at a time that mother of baby E and F is describing screaming horrendously and blood. And I want to remind you, at this point, Lucy Letby's supposed to have just stood around for an hour having caused bleeding, and then she's supposed to not have made this clear to the medics on the unit, and there's supposed to be blood streaming out of the mouth, but there's people coming in and out of the unit. Obviously there is, because it's 9 o'clock in the evening. The prosecution case, on so many levels for this infant, is just... I can't describe it any other way than utterly untenable. I feel there should be a stronger way of describing it than that, but it's stupendously ludicrous. It's obviously plain wrong. It's not even remotely feasible. But let's continue. That's why I'm saying this isn't about lying or a binary choice, and it's open to you and no one else, you, to draw your fair conclusions from this. but the graphic description we have, we suggest, does not fit well with other people being about the place and being involved with these babies at that time who see nothing that coincides with this. We can move from that, and we're going to move next to what happened when, the point of mother of babies E and F leaving, a conscientious mother and an anxious person. And she says, well, I left because somebody in a medical position said to go. She left, didn't raise anything with anyone else on the unit, and if she'd been told a doctor was coming, why not wait for that? There is an issue here, isn't there, about whether a doctor was there or not? There is an issue. David Harkness agrees that the timings and the making of his note at 22:10 means that he must have been on the unit from about 21:30 at the latest. He said that on the 17th of November, and when he got there, he saw a dirty aspirate which may have contained flecks of blood and bile. What does happen when they start CPR is baby E bleeds, and I'm not going to go through that awful detail out of respect to everybody because we've been there, we understand it, it's awful. We say that none of that fits with the collapse triggered by an air embolus, it does fit with heavy bleeding. The only person then who disputes that the heavy bleeding is linked to death seems to be Dr. Bohin. Well, what of trauma then? As opposed to a bleed that developed some other way, what of trauma? Because in the absence of air embolus, or maybe in tandem with it, Dewi Evans turns to an attack with an implement. For two of his reports, Dr. Evans says baby E's sudden demise was the result of an acute gastrointestinal hemorrhage. I am at a loss to explain the cause of the hemorrhage. This isn't typical of NEC. In the absence of a post-mortem, it's not possible to say whether baby E sustained trauma to the upper gastrointestinal system. That's right, ladies and gentlemen, and we say that's where this should end. Then in the third report, Dr. Evans suggested an injury caused by thrusting in a nasogastric tube. You'll remember this. A nasogastric tube is a very narrow, flexible tube. A nasogastric tube would never be capable of doing what Dewi Evans alleged, and in fact, he withdrew that suggestion in his report made a few weeks before this trial began in September 2022. So this was going to be another case in which they went into court saying something that they ultimately didn't rely on, and this was changed at the 11th hour. Of course, there have been multiple cases. The most famous is Child C, but this was another one where just right before the court case, Dr. Evans said, oh, hold on a second, I've just decided that my diagnosis is completely wrong. Not this a diagnosis, I mean, this is just batshit. It's just total rubbish. It's very obviously total crap. So we've gone from him saying baby E's demise was the result of an acute gastrointestinal hemorrhage. I'm at a loss to explain the cause in reports 1 and 2. In report 3, that changes to an injury caused by thrusting a nasogastric tube. So before we go any further, the reason he's at a loss to explain the cause is just simply due to a lack of competence, lack of knowledge, lack of experience, lack of recent practice, lack of ability. Whereas you see for the neonatal experts, they're able to do it because they have all of those things. But let's continue. That is dispensed with. We say you can see him involved in conjuring theories to support the allegation rather than reflect the facts. But having rejected the nasogastric tube theory, he didn't stop there. You may recall he arranged for the police to bring in an introducer, like he doesn't know what one is, but he arranged for them to bring him an introducer. Having set that up, we got served with the following part of a report or a statement only weeks before the trial, and it said this: I have not seen any statement noting the presence of an introducer. Therefore, my opinion regarding a potential cause of his trauma must remain speculative. I believe that it is reasonable to contemplate the possibility if a member of staff recalls that a redundant introducer was present around the time of baby E's hemorrhage. I believe it is an option that is worth exploring. I believe it is an option worth exploring. An option worth exploring. When we accuse him or other witnesses, prosecution witnesses, of seeking to work up an explanation to meet the allegation, I think an option worth exploring comes close to that. We say, ladies and gentlemen, the whole point is we are not to speculate. We are directed not to speculate. And how we're meant to be approaching this on, let's look at an option worth exploring, goodness knows. Are the police meant to go out and look for a witness to volunteer that? And nobody did, of course. But it gives away what's going on when Dewi Evans in particular, where this is concerned, presents himself or is presented as any kind of independent or objective expert. And we say, we can see there he's taking up the role of investigator, creator of theories, and coming up with speculative ways of hunting for evidence in search of a conviction. And it's simply impossible to disagree with that. We can see this pattern across the whole case. I've explained earlier exactly what he does in court. He does this over and over again. I can now understand fully his modus operandi. I've seen enough of him to know how he does it. The guy's a complete shyster. There were obvious failings in care in the case of baby E, ladies and gentlemen, in reacting to a clear medical emergency. And we say, as a result of that, baby E's bleed ran out of control and he died. The evidence for embolus is fanciful. I mean, I think it's generous to describe it as fanciful. It's just absolutely without foundation. And is based upon Dr. Hartness's shifting descriptions, and no amount of shifting was described in the notes at the time, though he described a rash that was appearing or in some way moving later, and that is that. And the rash is completely irrelevant. That's just indicative of a baby suffering collapse. We know why the baby's suffering collapse. Is absolutely obvious. There is no post-mortem and there is no examination identifying a wound to the mouth or throat, and Lucy Letby is getting the blame despite having seemed to have done nothing close to an attack at any point, and we say no realistic opportunity for an alleged embolus to have been delivered at the end. There just isn't enough, and it's wrong to proceed on the basis there is if there isn't. Firstly, before I go into the summary for this infant, I'd just like to emphasise that I will return to the prosecution cross-examination of Lucy Letby for Child E in the future. But compare the prosecution and the defence for this infant. The defence is citing to a great extent, although the defence's expert panel has added a few things as well, some significant points, but to a great extent the defence is just outlining what the expert panel would later state in its preliminary report, and there will be a detailed report with considerably more information. The prosecution has concocted a ludicrous narrative that is based on fabrication, lying, absolutely ridiculous interpretations, events that are logistically impossible, and of course it all relies on the laughable evidence of Dr. Evans. I don't think this can even be described as medical opinion on this occasion. It's just bullshit. It's pure bullshit. And yet, I know I've encountered people online, commenting online. I think they describe themselves as court watchers sometimes. So the court watchers all sat in court. I don't know if they were there for this particular infant, but if they were there for this particular infant, and I'll go on to talk about some of the people who we know were in court for this particular infant, and they thought the prosecution made a convincing case, then it's completely pointless for them to be in court. Same with Liz Hull. Liz, I was in court every day, Hull. She sat through all of this. So she's only too keen to remind us at every possible opportunity that she was in court. And yet she apparently thought that the prosecution's case was perfectly sound, seemingly. So we've heard this argument multiple times, countless times, ad nauseum. This argument of, oh, you weren't in court, so you're not allowed an opinion. Now, frankly, if you were in court for this case, and you think that the prosecution arguments regarding Child E were legitimate, and that it's a safe conviction, then it's pointless you being in court in the first place. You might as well have visited the seaside and had an ice cream and played crazy golf. You obviously have no critical thinking ability, and I don't think this even requires medical knowledge. Clearly you don't have medical knowledge, but you don't even have a reasonable quantity of common sense or general intuition. You might as well have not have attended court, complete and utter waste of time. If you attended court for this case and you think Child E, that what the prosecution said about this infant is more likely to be true than what the defence said and what the panel has said, you're an idiot. Anyone with medical qualifications will treat this as laughable. That's why I've spoken to multiple people with neonatal qualifications, with neonatal experience, and they've all said this is a very obvious naturally occurring gastrointestinal bleed. That's why the panel has said this. Look at the total nonsense and sophistry that the prosecution has put in court. And the worst thing is, this actually convinced people. I remember immediately after the court case, this was considered one of the stronger cases. And that's incredible, but it's absolutely true. And that's because of the emotional testimony from the parents. It's very easy to fool people with emotional testimony. We know that playing on emotion works. That's why advertisers do it all the time. I've explained previously that this gentleman on the screen now, Edward Bernays, was the person who was the kind of pioneering communicator of the idea that the best way to sell things to people is not to objectively explain their merit, it is to manipulate the subconscious emotions of people. So it's very easy to fool people by pricking their emotions. Essentially, that's why the prosecution used emotional testimony, and that's why it's been so effective with the so-called court watchers and the so-called journalist Liz Hull. Conversely, when you have actual knowledge or even a modicum of analytical ability, you see that this is a case that should never go anywhere near a courtroom, and that what the prosecution have said in court is entirely laughable.